The concept of separation of power is found from the writing of Aristotle, Plato, Cicero, and Bodin. Aristotle, in his book The Politics, stated there are three elements in each constitution in respect of which every serious lawgiver must look for what is advantageous to it. Of these are well arranged, and the differences in constitution are bound to correspond to the differences between each of these elements. The three are: first, the deliberative, which discusses everything of common importance; second, the official; and third, the judicial element. It has gained importance in the medieval theories of mixed government. During the reign of Edward I of England, the concept was argued.
In the modern political commentaries, John Locke forwarded the concept in two treatises of government in 1690. But the French political philosopher Montesquieu, who coined the concept of separation of power in 1748 in his book The Spirit of Laws, where he wrote as when the legislative and executive powers are united in the named person or in the same body of persons, there can be no liberty. Again, there can be no liberty if judicial power be not separated from the legislative and executive. The object is to safeguard the liberties of the individuals. Blackstone, the eminent British jurist who leaned towards the same view. The framers of the American Constitution were greatly influenced by this doctrine. Same in case of the France. James Madison, the founding father of the US Constitution, opined that the accumulation of all powers, legislative, executive and judiciary, in the same hands may justly be pronounced the very definition of tyranny. For this reason, all the major constitutions around the globe having the democratic form of government has accepted this doctrine. The striking feature that we find from the doctrine of separation of power or trias politica is all power of the government shall not be concentrated in single department or person, which will give birth of autocracy. The governmental powers are broadly divided into three heads, namely legislative, executive and judiciary. In modern democratic world, more emphasis is given to the independence of judiciary so that the fundamental rights and liberties can be safeguarded. Each department or branch of the government shall not encroach the playing field of the another. In practice, for the proper functioning of the business of the government, watertight separation of power is not possible. For the proper functioning, interrelation and interdependency exist, but there must be hairline or fine check and balance is obviously necessary to protect the liberties and the colorful fabric of the democracy. Otherwise, the nation will be under tyranny rule. Lord Acton had correctly remarked, power corrupts and absolute power tends to corrupt absolutely. We may conclude, in perspective of the Indian Constitution, the strict separation of power is not found as in case of the American and Australian Constitution.
Let us now sum up the significance and importance of this theory. 1. Safeguard of the individual liberty. 2. Preventing absolutism. 3. Smooth and effective running of the administration as a whole. 4. Independence of judiciary. 5. Preventing legislature from enacting unconstitutional law and executive supremacy. On the light of the above, the Supreme Court had pronounced various judgments from time to time. 1. Keshavananda Bharati case, where Supreme Court held that the amendment done in contravention with the principle of basic structure of the Constitution is unconstitutional. 2. Swaran Singh case, where Supreme Court held that the pardon by the governor to a convict was unconstitutional. Indira Nehru Gandhi case, where Supreme Court held adjudication of a dispute falls within the ambit of the judiciary alone, not of the parliament. In the matter of the separation of power, there are various articles speaks in the Constitution, such as Article 50, Article 123, Article 121 and 211 and Article 361. Let us now have a brief idea on checks and balances. Checks and balances are the system whereby each branch of the government have the power to restrain the other branch to become more powerful. The parliamentary system of democracy runs on the basis of checks and balances to prevent the autocracy of the other branch. Let us now discuss the controlling relation between the one branch of the government with the other. Legislative control over the one judiciary by impeachment of judges and amendment of laws that declare ultra vires by amending the same. 2. Over executive power to dissolve government by no confidence. Judicial control over one executive by judicial review, that is reviewing the actions of the executives. 2. Over legislature, reviewing the law passed by the parliament in terms of the constitution. Executive control over 1. Legislature, powers under delegated legislation. 2. Over judiciary, making appointment to the office of the chief justice and other judges.